Let's just move for the moment to your taking up an appointment on the New South Wales Supreme Court bench. You were talking before about the important formative experiences provided by the District Court of New South Wales. During your time on the New South Wales Supreme Court bench, you presided over what's been described as Australia's longest running defamation trial, which I know that was not something you wanted personally, and that was Marsden versus the Amalgamated Television Services case. Would you like to talk a little bit about that trial?
Yes, the trial itself took 2.5 years. The judgment was over 2,700 pages long. The libels were published on Channel 7 in 1995, and they were published just after the law had changed. And I was defamation list judge, and I thought, these are the first new cases under the new law, and that's the only reason why I took particular interest in them, little knowing that I would be managing them for 5 years and then presiding over a 2.5-year trial, which was absolutely exhausting. And whilst each side was perfectly entitled to conduct its case under the adversary system in the way it did, I think it stands out as a shocking example of a waste of time, resources, the facilities available in the courts, and I have no doubt that in the end the price became mortal as far as the plaintiff was concerned. It killed him. I'm not blaming Channel 7 for that, but that was one outcome. And I sat there often in absolute astonishment at the lengths each side was going to fight this case. It was a big case for the plaintiff and was, I suppose, for Channel 7. But no quarter was given, no. And there wasn't a light, there was one light moment in it, but normally in a case you need a light moment. In fact, it was my practice when you can feel the tensions to try and introduce a light moment, not a chance in this case. And the level of advocacy was excellent, and I had two great common lawyers, Bob Stitt QC and Ian Barker QC, who were brought in to argue factual issues, and they were of their generation, like Alex Shand and Tom Hughes were of their generation. That they were gladiators, and don't forget, I didn't have a jury, and that was 2.5 years plus the 6 months it took to write the judgment. I felt I was just lost from my life, type of thing.
Had it been conducted before a jury, do you feel things could have proceeded differently?
I think at first I don't think it would have taken so long. It might well have not proceeded to a result. It might well have settled because the jury introduces an element, an unknown factor. But people often overlook the fact that case was concerned with in excess, I think, of 30 allegations of child or sexual abuse or misconduct, each one of which had to be decided by me. And let alone the legal issues. And then it had a bizarre course through the Court of Appeal, and as I understand it, it was eventually resolved at mediation. But that I'm sure it exhausted absolutely everyone involved in it.
How much of that case do you believe was, in effect, a collision of all the things you've been speaking about, this collision between the invasion of privacy versus the reputational risk, the hurt feelings aspect of the plaintiff, This almost was the apogee, do you think, of that whole thing that you've been talking about?
Quite right. Leaving aside the absence of the jury, the Marsden trial had absolutely everything in it, from complex defences of privilege to excruciating issues of fact going to defences of truth, lengthy evidence on reputation, and a case of an immense injury to feelings. It had the works.
Am I right in getting the impression from you that in so many ways this case went counter to everything you personally feel is important about the law? Do you feel, in a sense, despite the outcome, no matter what the outcome, given John Marsden is now dead, do you feel a sense of personal deep disappointment at the way things went?
I feel disappointment that so much was expended on the pursuit by Mr. Marsden of a remedy and on the defence by Channel 7 of its right freely to telecast. It was thought that the hearing would take 12 weeks, and it took 2.5 years. And that was totally disproportionate, even to the issues, major though they were, involved.
I wonder if, while you sat through that case, or any other very lengthy case, and you've spoken about the lengthiness of many cases these days, do you ever think about that old Kenyan proverb, when the elephants fight, the grass beneath suffers?
No, I didn't think about that, but I don't think it's. I don't think it's inappropriate. It's not only the grass; it's in these ecological times. It's what's living in the grass as well, and depends upon the grass that suffers.